Good evening, everyone, and welcome to the Brian Crombie Radio Hour on Saga 960. I got a real interesting gentleman to introduce you tonight. Calvin Berry is his name. He is a criminal defense attorney right now. He's been a Crown attorney. He's got a huge amount of experience in the criminal justice system. So I thought it'd be interesting to chat with him a little bit about him, his career, what it's like to be a Crown attorney, what it's like to be a criminal defense attorney, and maybe some of his cases, and also a little bit about what lessons he's learned over the time. Calvin Berry, sir, welcome to the show.
Yeah, thank you, Brian. And a little sad that the Leafs didn't get to go where we wanted them to go. I was at all the games, at least the ones in Toronto, and I was out with a couple of my Crown attorney colleagues from the day and a couple judges that used to be prosecutors. But maybe next year. I was just going to give you a little bit of my background. I'm originally from Thunder Bay, Ontario, which ironically, for those legal pundits, that's the home of Chief Justice Bor Laskin and the Bor Laskin Law Library at University of Toronto. So small town, of course, in northwestern Ontario, Lake Superior. And I did my public school there and my high school. Then I went to undergrad at University of Windsor. And because I had grade 13 back then, I only had to take 2 years of undergrad. I took a business and commerce BCom degree. Didn't think I'd get in law school because I come from a pretty blue collar town, and I just thought I always wanted to be not only a criminal lawyer but a Crown attorney. Because in grade 11, my teacher took me to the high school in Thunder Bay, and I was looking at the judge, and the judge was a bald guy on top of the perch there, and looked like he was not too happy to be there and looked like he was bored. And then I saw the defense lawyer and walking around like a peacock in a nice big nice suit and kind of waiting to defend his next client. And then I saw the Crown attorney, and the Crown attorney to me was the beacon of justice. The prosecutor was surrounded by police officers. He had a bag of exhibits. He just seemed that he was doing something. And it just said to me, I wouldn't mind being a Crown attorney when I grow up. So I went and told my parents that when I was 16. And my marks weren't that good. They were really good in grade 8. And then I started to goof around like high school kids do and, not studying and all that. But then I made my direction. And in grade 11 and 12, I got over 80s. I became an Ontario scholar. I went to University of Windsor, only because there's a law school there, and they gave me a bursary, and they gave me $1,500 back in 1983, which I remember was a heck of a lot of money because I had the highest marks in my my class. And then I really didn't think I'd get in, so I just got the highest marks I could get in undergrad university. I joined a fraternity called Delta Chi in Windsor. Then I got in law school at Osgoode Hall Law School and all the other law schools. I wanted to go to Toronto because coming from a small town, it was like going to New York. I did a 3-year law degree at Osgoode Hall, and I was fortunate enough to get a job as a Highway Traffic Act prosecutor in night court at Old City Hall.
Night court?
From 80 to 86. Yep, it was like the old night court, like the TV show. And I didn't have to be a lawyer, but you had to be in law school, and you had to have a really good understanding of the Highway Traffic Act, the Liquor License Act, the Compulsory Automobile Insurance Act, the Provincial Offences Act. So that was kind of my into becoming a Crown attorney, because it was very competitive back then. Then I came articling after I got my 3-year law degree, and I've been doing Highway Traffic Act prosecutions for first-year law school, second-year law school, third-year law school. I used to have slept down on the bus all the way from Downsview, where York University was, to Old City Hall. And they paid me pretty big money back then. It was about, Brian, about $20 an hour for 3 or 4 hours from Monday to Thursday. And that was, 40 years ago. And it was big money to me because I didn't have much money. I worked at a paper mill, Abitibi Paper in Thunder Bay, to pay my law school. My father paid as much as he could. My father was an electrician. My mother ran the electrician business out of our basement. They ended up being married for 65 years, and they're 83 and 84. I'm 61, and I credit everything that happened to their motivation of me to try to, a lot of hard work and just get higher education. So then when you're in Osgoode Law School or U of T or Western or Queens, everybody wants to go to Bay Street and everybody wants to go to King and Bay and be at Tories or Blake Castles and have your corner office. I was pretty sure that's not what I wanted. But on the other hand, I wanted to find out what I didn't want. So I went to a articling law firm named Gardner Roberts. You remember Fred Gardner, Gardner Expressway, yep. About 85, 90 lawyers. Finished that, snuck around and did the night court every night, and then went back to work. And then I got called to the bar in 1988. And the only reason I got into the Crown's office, they said, well, you were at a Bay Street law firm. And they did offer me a job, but back then they would say, we got 10 students, we're hiring 3 of you. You're doing real estate, you're doing civil litigation, you're doing corporate, whether you had an interest in that or not, because people just wanted so hard to get into a big Bay Street firm because that was your ticket to, I don't know, that your great office. Career on Bay Street. Exactly. So I wanted to do the Crown attorney stuff. I wanted to work for the Attorney General. I wanted to be a Minister of Justice. So I ran to the Crown's office and they said, well, I guess you can't be that, ineffective if you got into these big Bay Street law firms because you have to have high marks. And we do like that you did your kind of your study and you got your experience as a Highway Traffic Act prosecutor. And back then we were allowed to go in front of provincial court judges to do appeals of careless driving, driving under suspension, failed to remain, bad car accidents. And I kind of sucked up a bunch of police officers I did a lot of cases from traffic, some of the justice of the peace, and my fellow prosecutors. They wrote some letters. So when I applied in 1988 to be a Crown attorney, the only other thing that saved me was at Osgoode Hall, they have a great criminal intensive program, and it's 1/6 of your 3-year degree, Brian. So I decided to do a placement, and you're either placed with, Eddie Greenspan or John Rosen, who's a lawyer for Bernardo, or Earl Levy, who was a big legend, Austin Cooper back then that defended Keith Richards, or you can go to a Superior Court judge like Judge Humphrey, Judge Locke, or you could go with a Crown attorney. And I wanted to go with a Crown attorney because I wanted to be a Crown counsel. So I went with a guy named James Ramsey at College Park Courts downtown. And now Judge Ramsey's a Superior Court justice. We remain friends down in Hamilton. So then I became a Crown attorney for about 17 years, did over 100 jury trials, did about 45 homicides, did a lot of big high-profile cases, a lot of NBA players that ran afoul, pardon the pun, beating up people after, games, and some NFL famous football players. I prosecuted Naomi Campbell, the famous model, and Brian Greenspan was the other side of that. She had took a mug and hit it on her EA at the Four Seasons when she was filming a movie called Exit Wounds with Stallone and I think Schwarzenegger. So I had so much fun prosecuting that, and I felt
what do you get charged with when you throw a mug? Assault?
Assault with a weapon or assault bodily harm. Yeah, and it was down at Old City Hall at the old City Hall courts. I finally got called to, after 17 years, I had a son, and he had a bit of autism, and so I had to go out to the dark side, to the defense bar, and start to make some further money for my new family. And then I defended, and I started with about 3 files and a secretary. Now I got to practice with about 30 people working for me, about 5 or 6 lawyers, paralegals, articling students, research students, and accountant office manager. We go all over Canada, but particularly Toronto and the GTA. I've got some cases in my hometown in Thunder Bay, and I've been in these courts pretty consistently since 1983. So I've been at it for about 40 years now. I do a lot of DUIs, a lot of domestic, some drug stuff, tax evasion, Ontario security stuff. And I'm 61 now. And so apparently I'm there's nobody that is as young as me, which is kind of funny, at 61 that has been in the courts as long as me, at least in the province of Ontario, of 40 years in the courts, and seeing them evolve and seeing all the courts close as you've been following, O'Brien, to the big mega court, which I've just started to go to now on Armory Street, downtown Toronto.
What's the big mega court? I didn't know about that.
It's a big court on Armory Street. They finally took College Park Court, which did all the crime in Danforth, Beaches, Regent Park, Yonge and Eglinton. They closed that after, I don't know, since the late 70s. They closed Old City Hall Court, which was open since the 60s. It's where the mayor used to preside, as you probably recall, at Old City Hall, 60 Queen Street West. That court's gone. I went to the closing of these courthouses and saw all my judge buddies and crowns and police and probation officers, and everybody was a little bit teary-eyed about the institution closing. 311 Jarvis closed the young offender court at Jarvis and Dundas for youths that are 12 to 17. 2201 Finch Court at Western and Finch is 90% closed except for bail courts now. And Scarborough Court in 1911 Eglinton is closed forever. So all these courts with, decades and decades of history have been morphed into one big attorney general court, 17 floors high, right across from 361 University, whereas that's the only place in Toronto where you can have judge and jury trials. For example, any of the big murder cases are there. So they're about 150 feet apart, and you have all your criminal justice at one-stop shopping, Brian. Now, as of basically March of this year.
Is it beneficial?
I think it is and it's not. It's been a real bit of a trying crying game because of COVID and the pandemic. The big court's having a lot of trouble convincing people that had free parking at the Scarborough Court at 19 Eglinton, where they could go next door and get a very reasonable lunch, to not having to commute because they all bought homes and lived around a Scarborough Court thinking it would be there forever. I mean, courts last, as you know, Brian, a long, long time compared to other, leases and buildings and maybe stockbroker entities. So they are very pissed and they're upset. And the court clerks and the court reporters and some of the young Crown attorneys and others are saying, we don't want to come down there. We want more money. This is chaos. We have to pay $30 for parking. We go for lunch. It's $40. We want to work at a home. So there's a big tug of war going. If you want us to come back to work, we think the hybrid and the Zoom way of doing trials on audio video is working fine. And we've been doing it for 3 years, and they don't want to change. Same experience with the North York Court at 1000 Finch, Dufford and Finch, that did all the arrests for all North York, including Jane and Finch, including Oakwood and Eglinton area, parts of Forest Hill and North York, Yonge and Shepherd, Don Mills and Eglinton. They don't want to come down. So these courts, I don't know if you've been following in the Globe and the National Post, it's been a real proverbial shit show because they come into court, the accused is there, the victim's there, the witness is there, the police officer is there, there's no court reporter, there's no court clerk, and the judge is sometimes not there because they just weren't set up to do an orderly, proper transition. The Attorney General is getting old people that they retired off to come back and run the machine because the left isn't communicating with the right, which is really unfair to the public and to victims of crime. And even the accused, the accused wants some finality, but
do the quick cases get thrown out in that case?
Exactly. Well, we're going to win because, I guess on a certain level, I got another great defense for my clients where if you don't get this matter on for summary conviction offense, which is like 90% of the offenses in Ontario, the whole thing gets thrown out. It stayed because it's prejudicial for the accused to have to wait while the government figure out the resources, their human resources, getting people to man and person these courthouses.
Why did the government do this? Is there a benefit? Is there a synergistic benefit? Is it technology? Like, why centralize it all? What's the benefit?
I think they thought if they put it all under one roof, there would be a lot of vertical integration. There would be a lot of, all one-stop shopping. The other problem you got, and this is going to be a big problem, is that, we got to face up. We're a big city. There's a lot of gangs. There's, Malvern gang. There's the Crips. There's all these kind of youth gangs out there. And when you have them all at one place, and the only time you'd bring them together if one is an accused and one's a victim, one's a witness, all you need to do is one dude to go and hit the fire alarm or call in a firebomb, and the whole courthouse has to evacuate, and you don't have any justice that day. At least before, when we had about 8 courtrooms Canada-wide, Toronto-wide, you'd only affect one. You follow? And Now that causes the problem. And it also causes a problem for potential terrorist attacks, in my view, because, a lot of times, unfortunately, and, knock on wood, the sites of a lot of these terrorist attacks are on government buildings, buildings of justice, buildings of government, and it's all in the epicenter of Queen's Park and the U.S. Embassy, because 361 University is on the west side of University, Brian, south of Dundas, and 100 feet across is this big mega courthouse. So I think a lot of things weren't thought through. I think the Attorney General, Don Downey, who's an excellent Attorney General, is a little bit overwhelmed. It's part of the Premier's plan to move quick and build and streamline. And I think along the way, we're going to lose a lot of justice in the short term, and hopefully it can be patched up and, that it gets back on the rails so there isn't too many cases falling through the cracks. Because I was a Crown attorney for a long time, and I've always been a promoter of, if somebody hits you or somebody allegedly rapes someone, or if there's a gun fired at you or someone steals your wallet, there should be an adjudication on the merits. I mean, we're in Canada. There should be a judge or judge and jury. The victim should tell a story. The accused should tell a story. And, there should be some finality. You either get convicted, you're exonerated, you move on. You get convicted, you pay your reparation, you take your punishment. But this kind of setup isn't really working because it's causing a lot of chaos to a lot of people. And in fairness, people that are, rotting in custody that don't have any prior records. And in Canada and countries like Australia and New Jersey, and New Zealand and England, nobody wants that. Nobody wants tens of thousands of people that are in jail, denied bail. It's an allegation. They haven't been presumed innocent. They get beat up in jail. Some have been killed in jail. The jails are overcrowded in Canada. So the answer is going to have to be more resources and more fine tuning to get room and space for all these backlog cases. See, the problem you got, Brian, it wasn't just his courtroom being built. The bigger problem was there was a backlog before the pandemic.
And it got even worse.
It's been exasperated. Yeah. So there's a lot of serious cases that should be heard on the merits that are at jeopardy. And I think, just from being a Crown attorney for a long time, on the other side, it's really emboldening these criminals to go, we can do whatever we want because our case ain't going to be for 2 years and I'm probably going to get thrown out anyway. That's what my lawyer's telling me. So these are some of the issues that, I knew I didn't really have to get a script. I just see what's going on. And if you read the papers, you'll see what's going on. But this should obviously be a big concern for the public. It sounds
like it should be a real big concern. No question about it.
Yeah,
Calvin,
yeah.
We're gonna have to take a break for some messages, and we're gonna be back in 2 minutes with Calvin Berry, a criminal defense attorney and a 40-year career in the legal circles in Toronto. Stay with us, everyone. Welcome back, everyone, to the Brian Crombie Radio Hour on Saga 960. My guest tonight is Calvin Berry. He seems like he's got a real handle on a lot of problems that are occurring right now in our criminal justice system. He's a criminal defense attorney currently running a legal practice that's got, what'd you say, 30 different people involved in legal work?
I got about 32 people, and I got some part-time and full-time, and that's just to make sure that we're, having people in all the courts, because we go all over Ontario and some other provinces, but mostly Toronto and the GTA.
And prior to that, he was a Crown attorney. And prior to that, he was a student that in law school did night court. And it sounds like it was kind of interesting dealing with traffic violations, DUI, et cetera. Calvin, let me ask you a couple of questions if I could. Zoom court, did it work during the pandemic with electronic video-oriented court rather than having everyone come?
I think it did. I think it saved a lot of money. I mean, Brian, it's pretty simple. It took away that thing that has been preventing people from wanting to go back to King and Bay, from wanting to go back and work. There was no commute. What a beautiful thing. You could prepare as a Crown attorney. You can do it from video. You could have your dog there. You could spend some time with your family. You still worked. You're still efficient. And everybody saw everybody. The judge was on Zoom. sometimes in court, sometimes not. That's what's called hybrid. And I thought it worked out really well. It worked out so all the downtime was taken away.
Yeah, I was told that in addition to the commute, that a lot of you lawyers just spend a lot of time waiting around if you go to actual physical court, and that
100%.
people actually adhered to schedules a lot better and showed up on time and finished on time. Is that the case? Was it more efficient for the lawyers and the Crown and the judges?
I think it was. I mean, there was the obvious glitch now and again, but like in any computers, but pound for pound. And it was so good that the Attorney General and the Solicitor General were kind of worried about, okay, the pandemic's over now. How are we going to get these people back? Because they've really, really kind of got settled in their pandemic ways. And a lot of people say that for serious matters, and I tend to agree because, let's take a murder trial where by law you have to be judged not by a judge alone. There's exceptions, but by your country folk, by your peers, by the people that are going to decide innocence or guilt. And because it's a terrible murder and the community's offended, we can't have prejudice. Well, that should probably be without video. That should be in an open court. That should be with the solemnity of the proceedings, and it's serious business.
I talked to a lawyer, Calvin. If I could interrupt, I apologize. But I talked to a lawyer, and that lawyer disagreed with that and said the reason why people want that in person is because they read body language, they read facial expressions, they read things like that. And the lawyer said, but that's not what you're supposed to read. What you're supposed to read is the facts. And so what people are doing is they're just sort of interpreting whether someone has a white hat or a black hat on, and coming to an emotional decision on an issue when they should be really making the issue only on the facts. And so therefore video is better because it forces the judge or the judge and the jury to make the decision on the facts and only the facts, not on their own personal jealousies or judgments or discrimination or whatnot based on this perception of what someone is saying and whether they're believable or not. What do you say to that, sir?
I think there's some traction to that, Brian. I disagree a little bit to the extent of the interpretation of law at the Court of Appeal, something called demeanor of a witness, the credibility of a witness, whether a witness is lying or, exaggerating. A lot of that is found in real life, in court, coming up, confronting the witness, being able to confront your accuser, i.e. the complainant. But I get it. A lot of it is in lieu of, you still have the video in terms of what the other lawyer was saying. And the video, you can see demeanor. Like right now, I can see if I said something to you and you put your head down, or you got, upset, or you turned all red. And then maybe I could say, well, the reason why you're behaving that way is because that you did it, or you're not telling us everything, would be an example of an examination. But you're right. It's just that there's optics in the administration of justice, and justice should be seen to be done. But my point is that would only take about 0.001% of the time of court resource in Ontario, because every 100 charges, I don't know if people know this, it wasn't like this 30 years ago, only about 5 go to open court, which now is video court. And so every 100 people that are arrested by police in Canada, about 5 or 6 actually go to trial. Of those
really?
5
That's
and 6
astounding.
now,
all the arrests get settled?
Yep, they do. They either get a peace bond, there's either a guilty plea, there's easy diversion, there's a fine, there's probation. You go side door left. The ones where there is a big public interest, for example, child sexual abuse, guns, of course, sexual assault, murder. These are the offenses that people say, well, you better prosecute those hard, and they require a defense lawyer. Those are the ones that would tend to have an argument to have at least hybrid. And hybrid means maybe the judge can be at home, but the Crown attorney should be allowed and the defense lawyer to be there with the victim. But I do agree with you. I think that hybrid worked. I think all video worked. And from my experience, again, from doing this since 1983, on both sides, I would favor probably except for a murder, except when you have to have a jury, which is first degree and second degree murder, having the audio video Zoom stay. And I think it's good for the victims. It's good for the witnesses. It's good for everyone because it makes it more comfortable too. And you still can hear, you still can make the arguments. I mean, just like you and I are having this talk, you could be a judge, I could be a Crown attorney, you could be a defense lawyer, and we're getting along fine. And, you know, if
Calvin,
we debated
if 95% of these cases get settled or something before they actually get to open trial, what's the key to success there? If you're advising a client and you're about to go into some sort of, I presume it's a negotiation between you and the Crown, what are the keys to success on that?
Well, yeah, let me leave you one other point, though, about why video isn't good. There's been some problems where, so a witness comes in, and let's say it's a big gang case. And so you're the witness, and I'm the judge, and I'll say, well, you're on audio video. Okay, you're going to swear on the Bible, you're going to affirm. You affirm, and we get that done. And then I'll say, I need you to show me that the door's locked. I need you to show me that you're the only one in the room. So you have to stand up with your phone or your tablet and go like this. And then we go, fine, because there could be a situation, as you know, say you're being threatened as a witness, and there's the biker dudes behind your desk going like this and holding up papers of what to say, right? But that's really the exception. And there has been some problems. And recently, if you look at the Globe and Mail, 3 dudes pled guilty to obstruct justice for that. But that's one of the exceptions to that last one. But moving on to negotiation. See, a lot of people don't understand. They think they watch US TV and they go, you know, this guy killed this guy and there was a trial and there was a jury and I'm suggesting that you did this and you don't have an alibi. That's not what criminal justice, at least in the year 2023, is all about. It's like this. You call me, you had a few, your boss said, Brian, you got to drive me home. You're a young journalist. You do, you thought you're okay, you hit a ride program, you get charged. Now, the legal fee is probably gonna be $10,000 or $15,000 to get somebody that is good to do this for you. So you lose your license for 90 days. That might cause you to get divorced. That might cause you to have a really tough time getting your kids to hockey and everything. You get a 7-day impound on your vehicle, and that's a police tax grab, and that costs you $1,500. You get fingerprinted and photographed. You have to have this hanging over your head, and your boss might fire you if he or she finds out. You might not be able to work if you're a truck driver, a police officer, or an ambulance person, or it's a precondition of your livelihood that you have to have a vehicle. Once I get up to resolving the thing, let's say that you blew 110, 120, the legal one's 80, and you didn't think you were drunk, you didn't get an accident, and you hit a ride program. I go to the Crown attorney and go, look, this guy can't have a conviction. If we have a trial, it's going to take 3 days of precious court time, 18 months from now. Why don't you give him a careless driving highway traffic act, $1,000 fine? He'll do some community service. He will be on highway traffic probation, which is not criminal. He has to have a blood alcohol concentration of 0. He has to take 2 courses about how dangerous it is to consume. He wasn't charged with impaired. He was charged with over 80. And just withdraw the criminal charge and we'll call it a day. He's paid me 10 grand. His wife's pissed at him, or husband's pissed at her. And if you think about that, you got punished. You got punished pretty good. You say you're 55, you've never been in trouble before. Nobody got hurt, and you get this highway traffic act, your insurance goes up, you get 6 demerit points. That's an example of a negotiation where it could all go away, and justice appears to have been done, and it probably has been done.
And does the Crown go for it? Does the Crown go for that?
Crown goes for it a lot of times now, especially now because there's leverage, because there is only so much scarce resource of precious court time where they want to put in somebody who's on bail, presumed innocent, on a child sexual abuse or a rape or a gun and fentanyl drug trafficking case or a murder, and reduce all that space so those cases don't become a jeopardy of getting thrown out because of the charter and reasonable delay and prejudice hanging over the accused. So, but even before that, that's an example where, you know, whether you are of an NDP ilk or a PC ilk or a liberal ilk, you might go, you know, when I think that I think that Brian got a pretty good, you know, kick in the ass there, because that whole experience with the fingerprinting and the handcuffing, all that might be enough to deter you anyways. And isn't that what the answer is? Throw people in jail. Does it make them better? They come out worse. As long as, you know, you don't do it again, I suppose, in terms of rehabilitation and denunciation and specific and general deterrence, we've all won, perhaps, rhetorically, right?
I think so.
So that's the way
you're right
I
in that
look.
regard. So
So
the
that's
answer
why
to my
that's an
question
example where things go.
is get a lawyer that can negotiate well with you.
Well, and you also have to have a lawyer that knows how to win, because if you don't know how to win, it's like, you know, it's like a boxer, you know. You and I are boxers, but you haven't boxed in your whole life and you're overweight now. And you used to be better than me, but I've been boxing every day. And your proverbial threat is, well, if we can't solve this, and if you won't take the careless driving, then why don't we go in the ring, i.e. the trial by the metaphor, and then I'm going to beat you down with all my legal arguments. Well, putting to the boxing analogy, I got something behind it because I'm going to beat you. And the same analogy is if I'm probably a specialist, or I am an expert in DUIs. Therefore, I have, what do you call it when you put your money where your mouth is? If we go to court, you're going to lose.
You're going to win.
Defense lawyer, you know what? So I think that there's no reasonable prospect of conviction, which is a test in the Crown system, and it's not in the public interest to go, because Brian really is contrite. I see he's crying in court now. I see he went and took rehab, even though he probably wasn't a full-on drunk. And he says this cost him 15, 20 grand. And his wife and him are going to marriage counseling because she just didn't forgive him. And, you know, just like jail, then they say the big things. The Liberals made jail federally years ago. You could do your jail at home. It's got a conditional sentence. You went and did something really bad. You beat up a guy in a bar and he had a black eye and a broken wrist. You pled guilty. You're going to do a year in jail at home. Everybody goes, well, he should go to real jail. Well, real jail will cost you about 100 grand a year. So a conditional sentence at home, that costs about 4 grand. You put an ankle monitor on, you're at home. You're allowed to leave your home for 4 hours a week to go to Shoppers Drug Mart. You can leave for a doctor appointment, and you can leave if your mother's with you. And otherwise, why that you have house arrest. Now, people say, well, what kind of jail is that? Well, if you and I got something like that and it got in the newspaper and you're at jail at home and you can't leave and you really can't work because your company doesn't allow you to do Zoom, then one might say that that's a deterrent. You're not going to do that again. So there's an example where if you told me, screw you, Barry, I don't want to do no jail at home. I'll roll the dice and get real jail. And then the Crown goes, all right. And they have a trial. And then they try very hard to get you real jail because you're so, you know, arrogant as an accused person. When the evidence was against you and you didn't listen to your lawyer, we're going to put the screws to you now. So I have to say,
does that happen?
Honor,
Do they get even more interested in victory if you turn down the settlement offer?
Sure. I mean, that's just life, and that's just, you know, and the problem is there's all these innocent people out there where the ones where there's innocent people these days, 99%. When I was at Crown, I would withdraw the charge. I wouldn't wait to take the chance. The ideology and the politic of the Crown attorney in Canada is that the Crown would rather have 10 guilty people go free than one innocent person be convicted. And those are the guidelines.
Do you really believe that?
I believe it because I was a Crown. And if I ever had a spidey sense that we might have the wrong guy, let's not even say it before my conscience.
We hear about these wrongful convictions all the time.
Well, when you look at them and you put them in a bucket for every one wrongful conviction, there's probably, I don't know, tens of thousands of people that are guilty that went free. Because this system, that's why we're not in Sudan, we're not in Iraq, we're not in Iran. We're in a system where it's very, very poor, and everybody wants to do the big blow-up story about the wrongful conviction. We got one of the best justice systems, and this is coming from a defense lawyer. But I was a Crown for half of my life. But
we got to take another break for a commercial. We'll be back in just 2 minutes with Calvin Barry. Fascinating, interesting conversation with a very experienced lawyer. Stay with us, everybody. Welcome back, everyone, to the Brian Crombie Radio Hour on Second and 60. I'm having a lot of fun tonight listening to Calvin Barry. He's a criminal defense lawyer. He has been a Crown attorney. He was a guy at night court, if you can believe it. He would probably be great on that TV show talking about night court experiences. Calvin, can you tell us, one or two of your most interesting cases?
Yep, for sure. I think Naomi Campbell was a big one because she at the time, and probably might still be one of the top 5 models in the world. Like she makes 10 million, 50 million a year. And the joke during when she got arrested and the police called her, she basically said, "Oh, wow, I don't get out of bed for anything less than 100 grand. And so what do you folks want? You're going to be arrested for an assault, bodily harm in Toronto at the Four Seasons Hotel with your executive assistant, a woman from London, Ontario, who's, you hit her with a cup and she has a stitch on her forehead." So Brian Greenspan was a defense lawyer who's a good friend of mine. I was a Crown. We were in front of Judge Ormston, great judge at Old City Hall. And they had to take her up for their entourage. And they're all ready to do a trial. And then the civil lawyers on the Naomi Campbell case phoned in. And Brian Greenspan said to the judge, "Oh, we just got $150,000 that the victim received. It's US, so let's not go ahead." And the judge goes, "What do you think of that, Barry?" And I said, "Your Honor, I think that an American law firm cannot buy our justice system. I think private law is when you do a tort on somebody and hurt them, they pay the money, kind of like the McDonald's person that gets burned with a coffee. But I'm a public lawyer. I'm a Crown attorney. I'm not here to win or lose, but there has to be some justice here in Canada for what she did to the victim, whether or not the victim wants to go ahead or not." And it looks like she still does want to go. She does want to go ahead, but she's happy for the money. And so, we can make it so I'm not going to ask for jail. But because she's made this recompense and the victim that isn't really that interested, but she's going to plead guilty. She's going to plead guilty to assault, bodily harm. She's going to get some anger management, some booze management, counseling. She can do it in Australia, where she's modeling right now, as long as we get a proper psychologist, psychiatrist, and addiction specialist. And she said, "Screw you." Okay, so we set a date for trial, and I guess she talked to her handlers, and Brian Greenspan spoke, and we came back, and she did that. So she pled guilty. We got it done. I was getting phone calls from Good Morning America, from the National Washington Post, and then the cameras were out, and I was a Crown for about 10 years in downtown Toronto. And at 5'8", I was able to say I was the shortest person to ever be on fashion television.
Awesome.
So that was that one. And then as a joke, she was in Playboy just before the matter closed, and the police officer and I, a guy named Detective Hayward from 52 Division, we got a Playboy book, and she was on it, and Hugh Hefner. So I went to Brian Greenspan and I said, we're all professionals, and I'm a Crown, and you're the defense. Can you maybe get her to autograph this? This is tongue in cheek. You can say to Calvin. So he goes, "Well, I'll try, Calvin, whatever." He comes back, hands the book back to me, and he goes, "Two things. She was never going to sign that book. And second thing she said to you, for me to say to you, you're a short asshole." So I took my book away and I said, "It'll be a great story that I tried to get the autograph." Then the poor thing, yeah.
Tell me about an experience as a defense attorney.
Well, when I was a defense lawyer, I did Rick Vive. He was the captain of the Leafs, and he got a DUI, and he was with some great Leaf legends like Derlago, and the agent was a buddy of mine, Trevor Whiffen, who is the agent for Don Cherry, Rick Vive, and a bunch of hockey players that came to the London Knights. And this was all over the TV and news, so I'm not talking out of school, but we had this trial with Rick Vive, and it was a very tough case because he allegedly, blew more than double, and we went and had this case, and it really was a hopeless case. We went up to Newmarket, and I had Rick Five beside me, and I had a young lawyer named Harville was my junior. Mrs. Vibe was in the dock. Derlago testified. Another guy named Maroon was involved, a 60-plus goal scorer back in the day that played for the Washington Capitals. And we really thought we lost the case. And so I told Rick Vibe to get ready to get up, and I had some letters and all that. And at the end of the judgment, as you'll see if you ever sit in a courtroom in Toronto, if a judge is going to acquit, they'll kind of go over and shit all over the accused and kind of go back and forth. But on the other hand, but I had a doubt about this, and finally said not guilty. And so Rick Vibe stands up because he couldn't hear that well from the way the courtroom was, and he was willing to say his swan song on why he's so sorry, but he was drinking and everything. And I stood up and go, Your Honor, just one moment. And I went up to Rick, I go, sit down, man, we won. And he sat down, everybody kind of giggled, and then we fucking won the case. So it was good. And it was nice because Rick was a good guy and he had a bad night. And the other funny part about it was the media came up and they took the cameras, and we were outside the courthouse in Newmarket, and Mrs. Vibe came up and kissed me right on the face. And so it looked like, the joke was, oh, maybe Rick was having some legal problems. So he told the wife to take good care of his lawyer. And so that was funny and then she gave Rick a hug after she kissed the lawyer. So I was going really happy, And Rick and I got along great because I'm from Thunder Bay and I'm a big hockey guy. I grew up in hockey and I played hockey till about 15. And the Stahl brothers are from the famous Stahl brothers are from Thunder Bay. Patrick Sharp, who's got cups from Chicago. You might remember Alex Del Vecchio, who played with Gordie Howe. A lot of NHL superstars came from Thunder Bay. So I was, it was a very fun case to hang out with my guy. I was my star, one of my stars, like he was in the same class as Bobby Orr and Phil Esposito and Brad Park and blah, 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 Gordie Howe. So he was a great gentleman. We're good friends now, but that was a funny case getting the Rick Vibe off, the captain of the Leafs.
Calvin, if someone listening tonight gets arrested or is told that they're about to get arrested on some criminal offense, what's your recommendation? What do you do? Do you call a lawyer right away? Do you write down what happened? What's the sort of the first couple of steps?
I think the best thing you got to do is you got to get a lawyer, and you got to get a lawyer as soon as you can. And, a lot of times police officers on your street are great because they know who the lawyers are. I act for a lot of cops, and I think that whatever lawyer the police association is using is a good start, because cops are pretty good people at the end of the day, contrary to some of the things that have been going on, unfortunately, these days. But then you have to shut up. You have to not talk. You don't know what you're facing. I've had so many people that even when I told them not to talk, they talked. And the only reason they got charged or the only reason they got convicted is that which came out of their mouth, out of their thinking cap. And if they wouldn't have said anything, they would have been fine. It's just best to say, I'm really sorry. The accused should play the bad cop, the good cop, I'm the bad cop, and go, look, until we can find out what this is about, just talk through me, officer, Crown attorney. That's the best thing to do 99% of the time.
So
sometimes
if a policeman knocks on your door, asks you to come in or asks you to come down to the station, you say nothing.
Nope. I got to call a lawyer, and I'll be in touch with you right away. And believe it or not, a lot of police like people who have lawyers. It makes your job so much easier. There's nothing worse than dealing with an unrepresented accused in court, because you have to bend over backwards to make sure that person understands this really complex, kind of myriad of procedure, evidentiary law, substantive law, the charter. And it's really a minefield for giving them a fair trial too. So, I find most police are very reasonable. I mean, I got a bit of an edge because I worked with the police for 17 years and I act for a lot of them, but it's never in your interest to speak. Now, once you see me or another lawyer that's able and effective and go, I think we should go talk to the police because you got 7 witnesses and they did a incomplete investigation. And once they interview your witnesses, I think they're not going to charge you. Or I think now you've been charged, the Crown attorney's not going to go ahead because there's no reasonable prospect of conviction, and we've amplified the reasonable probable grounds to show that it's not in the interest of justice to go ahead. So that's the way to do it. And that's the proper direction. And the last thing, if you ever, get pulled over for drinking and driving, which is what I call the most common white collar crime, badly, sadly, right or wrongly, it just seems to still be, is always blow. Always blow. If you don't blow, it gets a lot harder to defend. You don't blow if you smash your mouth on the dashboard, if you got super bad asthma, if you fell down and you chipped your tooth, and or if you got a break, the airbag and the seatbelt really can make it so it's hard to breathe. If you bruise the rib, don't blow. But if there's not been an accident and you're at a ride program, you should blow. If you don't blow, put it this way, I think I got about 70%, 60% chance of getting you off. And if you don't blow, you got about 20%, 10%. That's just something that a lot of people.
I got to ask you one last question. I was
don't worry.
I was a foreman on a murder case, and we found him. It was a police officer. We found him guilty, and I was surprised. I came in, and the judge asked me for the verdict, and I said guilty. And then the judge asked every other member of the jury if they agreed with the foreman. And the whole time I was supposed to look at the accused, and the accused was staring me down like crazy. I'm a pretty confident guy. I have never been in a more strange, vulnerable, scary situation than having this police officer accused of murder staring at me, as the judge asked every other person who in the closed room said that they had agreed with me, but now was asked again if they agreed with me. There's
law for that, and the reason that you do that, and as a defense lawyer, you'd probably be found to be ineffective if you didn't do that, and that's what happened in the Forcillo case, the attempt murder with the police officer with my good friend Peter Brody, Brauti. We both were prosecutors before, and now he owns about 5% of the Seattle Kraken NHL hockey team, the Kraken. Is the reason you poll each juror, and it's only at the request of the accused through counsel, is just in case there's one guy or two women that say, I was pressured, I kept on saying not guilty, and they kept on saying, no, you mean guilty, or something like that. It makes it, the verdict becomes 100% to 120%. Let's add the HST and GST, and then there's no doubt, because that person gonna stand up and go, do you agree with the verdict? How do you, what is your verdict? It is guilty. And then the accused, in fairness to the accused, can go and say, all 12 people said I did it. Because a lot of times in a jury, and I've been on Crown, and I've done more than my share, probably more than anyone my age. I've probably done about 105 now on both sides. I've always had that juror, whether I won or lost, that was staring at me. I don't know if they're staring at me because they thought I was a sleazebag Crown attorney, or staring at me because they're going, I hope you win this. Then you had a person always had their head down. And then he looked at you a few times, they had their head down. Then you had somebody who was crying. And they were crying at a kind of inopportune time when I thought they shouldn't be crying. So as a Crown, I always found out too.
You always want to find out. Calvin Barry, this has been a fascinating conversation. Thank you so much for joining us tonight and telling us a little bit about the history of Calvin Barry and the experience of being a Crown and a criminal defense attorney. Really appreciate it.
Thanks, Brian. And it was a lot of fun. And we'll probably see you at the next hockey game in the fall.
I look forward to it. That's our show for tonight, everyone. Thanks for joining us. Good night.